Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us. The Data Practices Office is a small office in the Department of Administration. We're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. The PowerPoint is posted on our website, so if you aren't able to download a copy today when I share it shortly, it is on the page where you registered. We also record our webinars, so if you miss part of today's webinar or you want to go back and watch it again or find one of our prior series, they are all posted on the Data Practices Office YouTube page. You can find the more information at the URL listed on the slide, and we'll have another slide later with more information on accessing those resources after the webinar. So if you would like to download a copy of the PowerPoint, I'm going to share the file right now. You should see a pop-up on your screen, and you can select and then download the PowerPoint to your device. Today's webinar is going to be another installment of Data Practices Potpourri, where we highlight some of the questions data requesters and government entities raised in the past few months. We will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so that we can be sure to see them. You can start sending questions now, or you can wait until the end of the presentation. Okay, so the first question that we received, how are Outlook calendars classified? The answer is it depends. In Advisory Opinion 96-055, the Commissioner opined that data in a government employee's appointment calendar were collected and created because that person is or was a public employee. Therefore, the data in the appointment calendar were classified pursuant to 1343. Minnesota Statute 1343, Subdivision 4 indicates that all personnel data are private unless specifically called out as public. Here, the Commissioner concluded that the data contained in the appointment calendar were not listed as one of the public data elements in Subdivision 2 of Section 43, so the data in the calendar were private. However, in Advisory Opinion 02-003, the calendar at issue also served as a telephone register. The calendar entries at issue contain details concerning public business of the government entity. In this opinion, the Commissioner determined that these data were not data on an individual, and therefore they could not be properly classified under Section 13.43. This opinion clarified that Chapter 13 classifies data, not files or records. The Commissioner stated that the government entity must provide public data contained in the calendar register that documents public business, even if those data are commingled with not public data, which may need to be redacted. Then in Advisory Opinion 20-003, the Commissioner reiterated that Chapter 13 classifies data rather than entire records or documents. So as government work has adapted, many calendars are now housed in Outlook rather than in individual appointment books. The classification of the data contained in Outlook calendars will likely depend on the content of the particular calendar entries at issue. The next question we received, a data requester asked for a police report by name and address. The arrested party in the matter requested to have the record expunged. The court issued an order expunging the record. The records were expunged at the time of the request. What can be released? So Minnesota Statute 609A.03, subdivision 5D, which is listed on the slide for your reference, states that if the court issues an expungement order, it may require that the criminal record be sealed, the existence of the record not be revealed, and the record not be opened except as required under subdivision 7. Records must not be destroyed or returned to the subject of the record. The practical guidance that we can offer here is to review the court order regarding the expungement to determine the specific conditions the court has placed on the records. If the court order prohibits the records from being revealed, you cannot acknowledge its existence. We suggest reaching out to your legal counsel for guidance to ensure compliance with any applicable court orders. Another important consideration with expungement is to ensure your entity has the adequate procedures and protections in place so that expunged records are handled and protected properly when these types of requests come up. The third question we received is related to body cameras. Is an officer entitled to access his or her own unredacted body camera data for personal use? So generally, inactive body camera data are private pursuant to Minnesota Statute 13.825. Government employees may only access private or non-public data with a work assignment that reasonably requires access. So here, if the officer is also data subject in the video and would like to access the body camera footage for personal reasons, rather than with a work assignment, the officer should comply with the entity's data subject access policies and procedures to ensure that the officer is only accessing not public data through the proper channels and with authority to do so. After submitting a data subject request, the officer may come in and review that unredacted footage in which the officer can be seen or heard, just as any other data subject would be able to do, or obtain a copy of the redacted body camera footage where any other data subjects who can be seen or heard are removed, except for other on-duty peace officers unless those officers are undercover. For more information on body camera data, we have an entire page on our website dedicated to this topic, and we have a prior law enforcement series that's on our YouTube page as well. This is another common question that we've received. How are vehicle identification numbers classified? There's not a general VIN classification, so as a result, we always start out with a public presumption. However, if the reason the VIN is maintained is because it is part of an active criminal investigation, for example, the data may be confidential during the active investigation. And then once that investigation becomes inactive, it may become public inactive investigative data under 13.82. We have heard of some entities using 1337 to protect VIN numbers as security data if there are theft or tampering concerns, but this is a determination that must be made on a case-by-case basis. Advisory Opinion 13-010, which is listed on the slide there for you, discusses a data request to DPS involving a security data determination. So if you're interested in what an entity might consider when applying that section, that's a good advisory opinion to reference. I also want to note that 1382 subdivision 20 states that data that uniquely describe stolen, lost, confiscated, or recovered property are classified as either private data on individuals or non-public data, depending on the content of the data. So if the VIN is maintained by law enforcement and could uniquely describe stolen, lost, confiscated, or recovered property, then this section may also apply. So the classification of the VIN will depend on why the entity maintains the data and whether there are any circumstances that would warrant classification under law enforcement data, Minnesota Statute 1382 or 1337 as security information. Our next question was, does a subpoena provide sufficient authority to access not public data? Generally, not public data may only be released to those with the statutory authority to access the data, a court order, or written informed consent from a data subject. A subpoena does not have the same legal authority as a court order. But it's worth noting that if your entity receives a federal administrative subpoena or a federal grand jury subpoena, you may be required to release the not public data requested in those subpoena requests pursuant to the Supremacy Clause of the U.S. Constitution. So if you work for a government entity and are served with a subpoena, you should always consult with legal counsel regarding your obligations to respond and how to respond. Many of you here are legal counsel for government entities and will likely refer to the Minnesota Rules of Civil or Criminal Procedure in filing an objection or motion to quash based on the not public classification of the data. At that point, a judge may issue a court order for the release of the not public data. Public data, on the other hand, are available to anyone for any reason or no reason at all. So any public data that would be responsive to the subpoena could be released. We have another advisory opinion listed on the slide here. It's 18-014. This advisory opinion addresses subpoenas for education data. As FERPA is also applicable to this type of data, this opinion indicates that a school district may disclose private education data in response to subpoena if the subpoena satisfies the requirements of FERPA and the entity makes a reasonable attempt to notify that student's parents. So again, if you're interested in additional information on subpoenas or data practices in the courts, we have another information page on our website that's dedicated to this topic as well. So how are correspondence with the local elected officials classified? So Minnesota Statute Section 13.601, Subdivision 2, states that correspondence between individuals and elected officials are private data on individuals, but may be made public by either the sender or the recipient. So if you receive a request for an elected official's correspondence, you'll want to determine whether one of the parties to the correspondence has requested the data be made public. It's important to note, though, that due to the private classification, this section only applies to data on individuals or living human beings and would not apply to data not on individuals such as companies or organizations corresponding with the local elected official. We have two advisory opinions that address this distinction. They're listed on the slide again. They're 10-025 and 18-013. Okay. Our last question is, are public bodies permitted to continue to hold meetings pursuant to Minnesota Statute 13D.021? So we received a few questions recently regarding whether public bodies can rely on that health pandemic or Chapter 12 emergency language in 13D.021 to hold fully remote meetings. Many government entities have returned to in-person meetings or are conducting meetings pursuant to 13D.015 or 13D.02, which both permit remote attendance under certain circumstances. In order for a public body to rely on this section, 13D.021, this health pandemic provision, they must determine that an in-person meeting or meetings conducted under 13D.015 or 13D.02 are not practical or prudent because of the health pandemic or Chapter 12 emergency. Ultimately, use of this section is a risk assessment for entities. We don't have any case law applying this requirement, so it's unclear what a judge or a fact finder might consider. However, if the public body or the government entity has otherwise returned to in-person work, it's unlikely that the entity has a strong argument that the in-person meeting or other remote meeting provisions are not practical or prudent, which is one of the first determinations or requirements that's required for relying on this section to hold remote meetings. So those are the questions that we received. Let's take a look at some of your questions. So please remember to send those to all panelists and we can make sure to see them. A few reminders on this slide while we're waiting for your questions to come through. The slide deck is available on our website and you can access the recording on our YouTube page in the next day or two. I'm also going to put an evaluation in the polling panel that you'll be able to fill out and let us know how we're doing and what other topics you'd like to see in the future. I'm going to share the PowerPoint again while you're entering those questions.
Okay, while Katie is sharing the PowerPoint here, we'll hop into some of the questions. The first one that we have here is what content of a complaint from a resident is considered public? Does it depend on which department received the complaint? For example, police department. Great question. And really what determines the classification or what data are going to be public from a complaint really depends on the type of complaint that it is. And so you'll want to take a look at the type and nature of the complaint because there's no general classification or no section that addresses all types of complaints. And so I'm getting the sense from this question that this might be a city that's asking this question. And so some of the sections that you may want to look at are, the law enforcement data section 13.82. There is a section about property data, that's section 13.44, section 13.44, which does classify the identities of individuals who submit complaints related to violations of ordinances. Their identities are classified as confidential. Other sections that may classify data related to a complaint might be 13.43. So if a resident complains about an employee, some of those data may be classified as personnel data under section 13.43. But if there's other complaints, such as someone just saying, hey, I don't like the condition of my road, or I'm tired of all of my taxes, those data might just be presumptively public, and because there's not a specific section that classifies those data. For state level folks, other things that you might want to take a look at are maybe licensing agencies. 13.41 would classify data about complaints, or at the county level, maybe certain welfare data. 13.46 would classify complaints there too. So it really depends on the content and the type of complaint, and you would have to kind of go to the appropriate section from there.
Another question we have from the webinar that we do receive quite often is the question about how are data requests classified? And it's going to depend on what the data request is for. We start from the basis that everything is presumptively public. So generally, if it's a member of the public who's asking for public data, whatever they submit as part of that public data request is also just public because there isn't a statute that would classify that. Now, if you have somebody who has welfare data that's classified under 1346 and they're asking for data about themselves, then that request would disclose private data about themselves, that they are a welfare recipient or that they're receiving services. So in that case, the data request would be private as it identifies that individual. So generally, again, public requests for public data by members of the public are public. And then if there's private data, if somebody's asking for private data about themselves, you want to take a look at the request and see if the request reveals private data about that individual.
Okay, another question that we received here is, can police departments show body camera videos for training purposes within their department? Another great question here, and the law isn't exactly clear on this. What I suggest taking a look at here is 13.825, subdivision 7 and subdivisions 8, and mostly subdivision 7 here, which provides guidance or directs when personnel within the law enforcement agencies or within a government entity can actually access the body camera data. All law enforcement agencies are obligated to have policies and procedures in place that allow their staff to obtain access to the data, to body camera data, for a legitimate specified law enforcement purpose. And so it really depends on your internal policies and procedures, what you have in place when it comes to accessing those body camera data. One thing I would note here is that there are other sections in 13.82. For example, the section or the subdivision that talks about 911 telephone call data does specifically call out that those types of data, those audio recordings, can be shared for training purposes. There's not a similar provision in 13.825 that says those types of data can be accessed for training purposes. And so at that point, I think it's maybe a risk assessment, and that would be a great conversation to have with your agency's legal counsel, and also looking at your policies and procedures for who can have access to that data. So ultimately, the answer to this question is it depends on your internal policies and procedures. If that may allow access for training purposes, then you probably can do that. If not, then probably not. But again, have a conversation with your legal counsel to determine who might be able to access those data, those body camera data in those particular situations.
Okay, we have another question here. It's a school district. We did an internal investigation into some inappropriate employee behavior, nothing raised to the level of harassment, sexual or otherwise. I'm wondering if the subject of the investigation would be allowed to view investigation notes from interviews with other employees, redacted or otherwise. So data on employees would be classified under section 13.43, and there is no confidential data on personnel, or no confidential personnel data, excuse me. So depending on who these notes are about, the subject of the data would be able to view the content, the data there about themselves, with redactions for any other data that are about other other employees in the data. So they would be able to view some of that data, but anything that's about someone else, another employee, would be redacted and not available to them.
We have another question here. Can a child support magistrate order the agency to release an order handed down from a DHS Human Services appeals judge to the appellant and the other parent in the CS dispute without an authorization to release the information? So this just comes down to when are you authorized to release not public data? And the only three options are generally with written informed consent, with a court order, or with statutory authority. And so you need one of those three things. If you have written informed consent that satisfies the requirements in the administrative rules, you can release the not public data pursuant to that written informed consent and whatever the constraints are in that consent. If you have a court order, you generally will need to comply with what that court order says. There is a process in Minnesota Statute 13.03, Subdivision 6, regarding the discoverability of not public data. Where if a government entity opposes discovery of data or release of data pursuant to a court order on the grounds that the data are classified as not public, there is a process there to object and have the judge review the data and then weigh the benefits of releasing the data or providing limited access or not releasing the data. And so I would suggest that if there's a court order, to have your attorney review that section under 1303 subdivision 6 and see whether that's applicable to the situation. But generally, there has to either be an informed consent, a court order, or some other statutory authority.
Okay, another question that we have here is, could you clarify the scope of criminal record for purposes of expungement? Is there a definition that includes a police report or similar data? In this situation, I recommend taking a look at section 609A.01. And so that's in that expungement of records statute that was cited earlier. It does have some explanation there of what criminal records that fall under section 1382, 152.18, and 299C.11. And so take a look at 609A.01 when it comes to what records might fall within that scope of criminal record. And additionally, you would want to take a look at the expungement order itself. There may be some direction in there about the scope of records that you may need to expunge or fall within that expungement requirement. And so the expungement order itself is also going to be helpful in those types of situations.
All right, we had a question. Is there any consideration in your office or elsewhere to establishing a standard for when Data Practices Act constitutes harassment? So if you have excessive or repetitive requests. So this is a great opportunity just to remind folks of kind of what our services are here at this office. We help both members of the public and government. And so generally, we stay in the middle in terms of any sort of policy discussions and legislative changes that don't directly impact the work of this office. So our office does not have any plans to advocate for that kind of standard or to change anything at the legislature. I certainly know that this is a conversation that's happening amongst government stakeholders a lot to determine whether requests might be harassing. And again, what's harassing and what's just difficult to comply with can be two different things. And so that's a challenge for government to consider. But there isn't, as far as I know, right now, there isn't any movement towards creating a standard, and that would have to be created in statute. So if you are a government entity and you're interested in that, you want to talk to your lobbying organizations and tell them what you would like to see with regard to that kind of effort.
Okay, we have another question here. So in response to a request for data regarding how particular funds were spent, a finance department produced a spreadsheet that included employee names when the expenditures related to the employee's use of their purchase card. So must the employee names be redacted from the spreadsheet as private personnel data? Yeah, so under 1343, the personnel data section, personnel data is really defined as government data on individuals that's maintained because the individual is or was an employee or an applicant for a government entity. So it sort of depends on the data and why it's being maintained. But here, in response to a request for some finance information, the mere presence of an employee's name doesn't necessarily mean it's private personnel data. It's really about why the data is maintained and who it's actually about. If it's about the finances and the employee's name shows up, it's not necessarily private personnel data. But if this is data maintained, sort of tracking the employee and their expenditures and their work, then you might consider it personnel data under 1343. So it's going to be dependent on the data itself.
Okay, another question that we have here is when receiving a request for records or data from a law office or disability determining services office, we treat this as a data request from a data subject. Do we need to verify the identity of the data subject if informed consent and other personal information is provided? So this is a great question that we often get is, can I just treat, an attorney who says they're representing someone as the data subject and hand over the data to them? So your obligation under the law is to, make sure that you're protecting not public data. So any public data that these folks are requesting, you can certainly turn over to them. But if, an attorney comes in and says, I'd like to have all private data about my client, then I think it really is up to your internal procedures and processes to ensure that that attorney is actually representing the client. And so I think the safe way to do that is to make sure that there is an informed consent form completed and that you've verified that the person providing informed consent, that it's written and that the person is who they say they are. And so whether it's having some sort of other confirmation that the informed consent is accurate and complete, or the person who is has signed the informed consent is who they say they are, yes, that's totally reasonable and probably appropriate, as you need to protect not public data about those individuals. And so you need to have those processes to ensure that you can confirm the identity, and whether it's having someone come in, that's all to your internal procedures, to what you feel comfortable with. But certainly we would encourage you to say, hey, if an attorney's coming in, get some informed consent. When it comes to Disability Determining Services Office, there may be statutory authorization to share not public data in those situations. And so if someone does come to you and say, hey, we're authorized to receive this data, under law, certainly ask for those statutory requirements or statutory sections that allows you to say, hey, what allows us to share those in those situations? So case by case basis, but you need to do what you need to do in order to confirm that you can disclose private data to a third party through informed consent.
Another question here, it's how How do you respond to an individual's request to view in person their own private data when it is in an electronic form and contains private information on other individuals? So this comes down to an internal procedures or process question. You always need to you'll need to redact that private data on those other individuals, and how you do that will depend on the data that's being inspected, and you'd likely redact the data as you would if you were to provide copies to the data subject. And so there may be different tools that you have at your office to redact data electronically. I would likely discuss if you have a records manager, or potentially consult with your legal counsel on how they would recommend that you redact the data in order to ensure that you're properly de-identifying not public data on other individuals. But there's more than one way to redact information.
I'm going to get one more question in here, which is the city's EIN or state tax ID number public information? So I'm not aware of any classification for an employer ID number or state tax ID number for a government or employer. So I think it is just public information. It's not like a social security number that has a specific both state and federal classification. So I believe that information is just public.
So we are at time today. If we didn't get to your question, we will be reaching out to you directly. Please, if you haven't already completed the poll that's open in the polling panel, we'd love to hear your feedback on how we did today and any ideas you have for future topics that we can cover. Thank you. If you'd like to reach out to us directly, we have our contact information on the screen here. We also have our future webinars for our next Potpourri, as well as our upcoming workshops listed on our website. We have an intro workshop coming up later this week, and then we have a personnel workshop scheduled in October.